Hi, this is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, every week, we do bring in updates, but we do have an important update right now where the entire F1 regulations have completely changed. How the visa will be issued, how the OPT has been can be issued, how the STEM extension is not only for the people who are going to come into United States. This is also effective for the people who are already in United States. Emily, what is this regulations? When is this effective date? How is it applicable for the existing students?
We're going to get the official publication of the regulation tomorrow, and it is scheduled to take effect 60 days after that. So we're looking at approximately September 15th, 2026. All the new rules will take effect, and it ultimately eliminates the use of duration of status, or D/S, for F1 students. So when you come into the US currently, you receive duration of status on your I-94. That means as long as you're studying and you are getting a valid I-20 from your school, you can continue in F1 status. You never have to file anything with USCIS except for your OPT or your STEM extension after you graduate, or reinstatement if you need that. Going forward, that is completely different. You are going to get a specific end date on your I-94 that's tied to your program. And in order to extend beyond that, when it's time to file a OPT or your STEM extension or change programs, you are going to have to also file an I-539 application with USCIS. So double filings for any kind of change. So there's a lot to get into. That's just a very brief overview. I think we want to really talk about how this impacts current students, because there is definitely an impact for those who are already here and have duration of status on their I-94s.
Stephen, let's focus only on the students who are already here, who are on F1 student visa status, though. So let's say if they want to file the OPT right now, do they need to file the I-539, or they just file it regularly? Previously, for filing an OPT and STEM extension, all they need to do is get an I-20, and then they will file for the 765. Stephen, what is the deadline? What is the timelines when Emily is saying that they need to file I-539, but when is the timeline for it?
Yeah, I mean, my reading of this, and please, y'all, it's early morning here. Correct me if I'm wrong. Is there is this 6-month transition period or ramp up period, whatever you want to call it, that if you are in F1 right now and apply for your OPT during the next 6 months, starting from tomorrow, you don't have to follow these rules. Okay, you don't have to worry about the extension of status right now. If you graduate, though, in the spring semester, which would qualify you for OPT, you are going to have to do the extension of status. Emily, am I reading that right?
Yeah, so it's from September. So you basically have a window between September 2026 and March 2027. If it's time for you to file your OPT or your STEM extension within that window, you are fine. You do not need to also file an I-539. You just file the I-765 like you would normally would. If you are going to be filing your initial OPT or STEM OPT after March 2027, you will also need to include an I-539, even though your current I-94 is for duration of status. And that's because you are going to get a new program end date on your I-20, which is going to extend out your F1 status. So you have to also file for an I-539 after March 2027. Those are for people who are currently in the US or entering the US before September 15th, 2026.
So
Now,
for Emily,
Emily, if I remember right, you can apply for your initial OPT 90 days ahead
before
of the end of your program.
graduation.
So
Yes.
I would want to tell students to track this, right? So that way, instead of waiting until the last minute, maybe they apply earlier than normal so they could, at least on that initial, right? So if we think May graduation is typical for spring, they should be good to get into this transition period window if they file
Yeah,
in
it's it's going to be tight for sure. Because if you're talking like a May 15th graduation date and program end date, and so 90 days before that is going to be March 15th. So it's right around then. So if you have an early graduation date in May, you might be able to work it out to where you can file your OPT without needing an I-539. I believe the effective date to be aware of there is March 15th, 2027. We'll know that for sure tomorrow once the official publication comes out, because it'll give all of those dates.
And I assume NAFSA and all that's going to be sending out all sorts of stuff to the DSOs and everything on this.
And SEVP for sure.
Oh, yeah. There's going to be a ton of new guidance from SEVP and NAFSA coming.
So coming to these regulations, Emily, so this is going to be published. We already got it. We know that it's going to be published on Friday. Every Friday, these Fridays are dreaded for us that they're going to publish this on Friday. And it's going to be effective, if I'm not mistaken, on September 17th, if I'm not mistaken, or September 15th, 16th. And there is a transition period for some of the people until March of 2027 for the people who are already in USAs, right? That means that these people don't have to file the I-539s. They don't have to go through the new things. But for the people who are traveling into United States, visiting by going outside the country and coming back into United States, they will be applicable with the new regulations as soon as they come in, because they will be issued the I-94 based on the I-20. When the I-20 is expiring, their duration of status will be cut down, especially from September onwards. They will be cut down to their duration of status. For those people who are traveling outside the country, this new rule will be applicable. For the people who are already existing, most of these rules, if not all of these rules, are not applicable until March of 2027. What about the rules?
Unless you travel.
Unless you travel.
I want to really make emphasize that, because if you are currently in the U.S. on F1, and you leave and come back on F1, the new rules will apply to you, even though your current I-94 says duration of status, which means another reason not to travel.
I was going to say, for the last year and a half, have we had any laws where we haven't said don't travel?
I don't think so. Yeah, so do not travel, because otherwise everything that you've, understood for F1 goes out the window after you come back. I also want to mention that for people who, on the effective date of this regulation, already have their I-765 filed and pending, they don't need to worry about these changes either until it's time to file like the STEM extension a year from now. So as of now, if your OPT or STEM OPT is already filed, these rules will not change anything. You do not have to file a separate I-539.
And for those people who are graduating in May of 2027, how long before they can file the OPT, Emily? The rule says, I think so, you can file 90 days before graduation, is that right?
Correct. So 90 days before, and now it's only 30 days after. It used to be 60 days after. So that's another change.
So we still have 90 days before graduation, they can file the OPT. So 90 days, if they're graduating in May though, then practically they can file the OPT and STEM extension if they file it before March 18, 2027. But if it's after March 18, 2027 though, then they will have to file an I-539. Now, do they need to include a lot of other documentation? When we file an I-539, we have to file that they're maintaining the status and all those things, that they intend to depart after they're completing the OPT. A lot of different things we have to file when we file I-539. So all those rules are still applicable, Stephen and Emily?
Yeah, I'm going to say 100%.
I think yes. And then, I almost think we want to show kind of those discretionary factors, Emily, as well when we go through this. This is, they're kind of saying, oh, we're not attacking the OPT and all that, but this is kind of a way that I think kind of does negatively impact that OPT. And we've got a couple questions about day one CPT, Emily and Rahul. And this is highly impacted on the day one CPT. One, with all these extensions of status, you can only go in an upward trajectory. You cannot go for 3 master's degrees or a second master's degree. You can only get the extension of status at the same degree level. You can't transfer schools on a graduate program or higher either. And so I do think these day one CPT programs are going to have a significant impact when it comes to this regulation.
So
Yeah, I
right
mean,
now,
if you come for your master's degree, you graduate, you get your OPT, you have 1 year, you get your STEM extension, you have 2 more years. During that time, if you are not selected in the H-1B lottery, a lot of people choose a second master's at a day one CPT school so that they can continue to work while they wait for the next lottery to come around. That option is gone. No more second masters at the day one CPT schools. You have to do a PhD. And once you finish your PhD, there's no option after that. There's nothing higher than that. So you are capped out of the F1 program once you finish a master's and a PhD. And as Stephen said, you cannot switch programs, switch schools within the first year. It's very difficult to do that. You would have to file an I-539 in order to go back to school for your PhD, which means that all of the program requirements are going to be questioned. They're going to be questioned if you did the day one CPT, did it qualify? Was it properly authorized? So there's going to be a lot of scrutiny on day one CPT because now we have to file I-539 applications.
And to be fair, we've always mentioned that there were potential risks and issues. I mean, I don't think any of us are fans of these day one CPT fly-by-night colleges. So just
Yeah,
know
one
that it's going
other
to get tougher.
big thing for people to be aware of is unlawful presence. So during the prior Trump administration, they had tried to issue a policy update to change the idea of unlawful presence specifically for F1 students, because normally if you're given duration of status, unlawful presence only takes effect when you overstay your I-94. Well, there's no end date, so it's not possible to overstay an I-94. That is all changing. They tried to change it before through a policy update. Now they're changing it through this regulation to say that if you violate your F1 status, unlawful presence kicks in, even if it's before the end date of your I-94. So be very careful with any kind of violation of status, no unauthorized employment. Just make sure that you don't fall below your class load or take too many online classes. You need to be very careful about maintaining your F1 status so that you don't accidentally trigger unlawful presence.
and for those people who are entering into United States right now, this rule is only applicable for the students who are coming in September, though. For those people who are coming before September 15th of 2026, they will still be given duration of status. It's only on or after September 2026. The new rule will be, if they're coming in, they will be restricted based on their I-20. And
I think
this rule, go ahead.
Oh, go ahead, Rahul. No, go ahead.
This rule also, some guy was asking question, what about the people who are graduating in December of 2026? STEM students, they can apply for the OPT under the normal circumstances, 765. Nothing is changed for them because for them, the effective date, if you're filing an I-539, if you're filing an OPT, is March 18th, 2027. So for those people who are filing an OPT on or after March 18, 2027, the new rule will be effective. Then at that point of time, you have to file a I-539. For those people whose OPT and STEM extension would be pending by March 18, 2027, they still don't need to file an I-539. Now, Stephen, what is involved in I-539? Why are you guys so scared of I-539?
I mentioned this when the three of us were prepping. If you really think about this, there's a lot of this that makes sense, right? It kind of matches every other visa program, except for the fact that this would make sense if we dealt with a competent agency. And I'm not, I like to hate on Joe Edlow. He's not the only director that's been incompetent. Okay, here Judeau wasn't great either. There are delays when with processing and with these I-539s especially. And if there's not a premium processing option for both of these, and then what are we going to do about the F2s? And how do we work this out concurrently? Do you pay double premium? The delays are where people can have real impacts. And that's what we see day in and day out with all sorts of other visa categories. And so now we're going to add more filings, more I-539 filings, not necessarily, everybody that wants to say, oh, we're here just to make money, not necessarily through attorneys. We're just going to see a boatload more I-539s that the agency then has to adjudicate. How are they staffed up to handle this? So we're going to see delays. I'm not against it. I'm not against the idea of filing I-539s. It kind of makes sense that we're going to treat these like every other visa category, other than the fact that it's weird. You've got some that have two different forms to get the work, but I just don't trust. And again, I hate on Joe Edlow, but it's an agency issue. USCIS is incompetent as an organization.
So
yeah, I mean, if you think about this, like, it's basically become what we do for an H4 and H4 EAD, right? So we have to file an I-539 to extend the H4 and then an I-765 to extend the H4 EADs. Stephen, how many lawsuits are you filing for delays in H4 and H4 EAD processing because they're not bundling with them with the H1B? They're not processing them quickly. You can't work on the EAD because your H4 is not yet approved yet. They won't approve. Yeah, and there's no premiums. And we don't know yet if there's going to be premium for this type of I-539. There is premium for a change of status to F1 on an I-539, but there is not currently a premium for an extension of F1 on an I-539. That remains to be seen. And if they do add that, great. But now does that mean you have to pay the premium for the I-539 and a premium for the 765? Because most people nowadays have to file their OPT and their STEM OPT in premium because processing times are so long. They're losing out on job offers, having to push back start dates, running out of the 180-day auto extension time. And that's before we add in all of these I-539s that they're going to have to be adjudicating on top of everything that they're already adjudicating poorly.
Yeah, I mean, again, I just, none of this bothers me. The idea of students, they cite to a handful of examples of these career students. It's not a ton, right? But they cite to a few. And if the agency wants to vet that, okay, that is the agency's prerogative. I don't have anything against that. I just know that what's going to happen is this is going to start here in September. So what, come January, we're going to start getting all these calls about issues, with delays and whatever and whatnot, because we continuously have seen an agency of incompetence, whether it's your Judeau or Edlow or whoever's in charge. It has been incompetence after incompetence from the agency.
Do we want to take some of the questions?
Yeah, what are the students who are coming in before September 15th? I don't know the exact date, but yeah. No, they will still be issued. They should still be issued the duration of status. It's only from September. What date was that? September 15th, they are going to be issued only up to the time their I-20 says. But for those people who are entering before September 15th, though, they should be issuing still until the duration of status.
Harsha from X says, I'm traveling this month. I'm in my final year of STEM. Is it the ideal time to travel? No. But if you are going to travel, you need to come back before September 15th, because then you'll be able to get the duration of status I-94 rather than an I-94 that ends on your OPT end date.
If existing students who are wanting to extend their timing, though, for example, if their I-20 expires in December of 2026, and they have more time to graduate, they need to file an I-5. For these students who are is moving from one university to another university, there is a possibility he can get it. It may be a little bit more restrictive, but if he's going to still graduate within the I-20 time that was being given for the previous university, he file an I-539 form. If he is going to take more time than the actual previous university, he would be required to file an I-539 form.
VACA US says, how about students graduating December 2026 in STEM? So you would likely be filing your initial OPT before the March 2027 cutoff, which means you only need to file an I-765. The old rules apply. But after your initial OPT expires, when it's time to file your STEM extension, then you will need to also file an I-539 application along with it.
Okay. So what if my OPT is expiring? How if you're going to file this STEM extension, as Emily has pointed out, it's better to file before March 15th of 2027, the STEM extension later on, because you would be 539 if you file a STEM extension on March 18th, 2027. So since that's very important, guys, for the STEM extension people. File the STEM extension before. I-539, we have submitted the doc. If you have to file I-539, you have to submit the documents, not only what you submit for the I-765 form, but you have to request them why you're extending. You may have to include the statement that you would intend to depart United States after completing your program, and satisfy the requirement, and you will be up to the discretion of the officer. It's like whenever you're filing an I-539, I call it as a they put 6 bullets in one gun and then they rotate it and they put it here. Oh, I'm alive.
6 bullets
Next
or just one?
Oh, sorry. 1 bullet. Okay.
I don't want to play Russian roulette with you.
Ooh, no.
No, okay, now I changed the word. You're right, Emily. One
bullet.
I'm alive. And then I give to Emily, and then Emily has to put it, and then Stephen, let's see who goes up. When you're filing an I-539, that's how the situation is. But however, Emily, I may have to disagree with you on that 1 bullet, 2 bullets out of 6, though, especially when it comes to I-5. I think so is that it's not going to be 1, it's not going to be 6, as I said. It's going to be 2 out of 6.
Question here on YouTube: what if you need the second master's for your career? So the way the rule is written is it says you can't get them outside of extraordinary circumstances. So if there is a legitimate educational need, I guess you could file the I-539 and try to convince them. I don't think it's going to be highly likely, though.
I think you could travel and apply for the new visa and come in. Of course, are you going to get the new visa? Probably not,
that's
but
a good
that's
question.
what they would want you to do. DKJ says, what is the chance of litigation stopping this? Did they follow all the rules? Nothing jumps out at me that they didn't follow notice and comment administrative APA procedure. I don't see an area for litigation. Obviously, we've only gotten this today and it's 500 some pages, so maybe I've missed something. But I have a feeling this is going to take effect.
I think the only thing I could sort of see, and I don't even know if there's a cause of action. It's kind of a reliance interest for people already on F1, getting the rules changed. But they can do that, right? They've gone through the notice and comment, and I'm sure there are groups going to be looking at this with fine tooth combs and go through everything. I mean, notice and comment rulemaking, we don't have to like it. It just has to follow the procedure.
Okay, questions that are coming here. You guys are a little bit vague on when the I-539 should be filed. Will the DSO inform us about when we should file the I-539? Will the USCIS inform us about it? Well, watch for us a little bit later. This 500 patient just came 1 hour ago. It takes a little bit time for us to digest it. No, the USCIS will not tell you, Mr. Subbarao, you need to file an I-539. They're not going to say it. Your DSO may not be able to tell you that when to file an I-539, when not to file an I-539. If you think so, we are vague. Yeah, we kind of right now. I agree with you, but we want you to keep following our YouTube channel so that we will inform about it later on. But no, the USCIS will not tell you that when to file 9. They will not really tell you on that thing. Your DSO may not be able to do it, but keep watching our YouTube channel. Please subscribe to our subscribe to the blog so that we'll inform you when not to file.
And on that topic, I mean, remember, if you're entering the US after September 15th, you're going to have an end date on your I-94. That means if you want to stay beyond that date, you 100% have to file an I-539. So that's going to be easy. Nothing vague about that. The vague part is just for people who are currently in the US with a duration of status. And that is anybody who is filing an OPT or STEM extension after March 15th, 2027 is going to need to file an I-539. If you are in like a PhD program right now and you're supposed to be here for 5 years and you have that duration of status, there is a maximum transition time of 4 years. So if you've not graduated by September 2030 and your I-94 says duration of status, you will need an I-539 in 2030.
I mean, we are going to see some guidance, I think. Study in the States is going to put stuff out. SEVP is going to put stuff out. Like, we are going to see, not everybody's going to have to read through this 500 plus page notice and comment to figure out what the heck is going to have to happen. But there is going to be aspects of this because it is got a transition period that is a little bit confusing that we're going to have to work through here, in the coming months.
With regards to when we file an I-539, Emily, is what documents are required? Of course, when we file I-740, we have to get the I-20 endorsed, and we have to pay the money. We have to file the application form. And when it comes to the STEM OPT, we have to file the, 983 form, and then we have to get the I-20 endorsed, and we have to file the application. Is there any extra documentation we have to do? Do we have to document that I'm going to return my home country after I return to the home country? Or need to have a statement, because all those things are those statements that I'm going to return to the home country, or probably a ticket going to home country once completing the OPT STEM extension. Those are not required right now. Are they required for the I-539 form if I file it from March of 2027?
I expect that they will be. The only way we will find out what they want is when they start sending requests for evidence after we file our first round of I-539. So I'm going to assume that I need to submit I-94, prior I-797 approvals, if there are any for your particular situation, passport, visa stamp, transcripts to show that you've been maintaining your status, maybe your degree certificate if you've graduated, proof of a residence abroad that you've not abandoned, probably a written statement about your intentions. Why did you choose this program? Why are you choosing to work? How is this going to benefit your career abroad when you leave the US? Bank statements or pay statements if you're already working. I think all of that's going to be expected. But again, are just going to have to assume what's required until we either get updated form instructions or we start seeing RFEs asking for things that we didn't think of.
Yeah, I think too. I mean, we keep talking about that, the D word, in the last year and a half, discretion, those positive discretion factors too. I think you're going to want to go through that as well, potentially.
And one of the gentlemen is asking the question, do I have to prove my continuous employment on OPT when I apply for the STEM extension? Previously, they were just filing with the endorsed I-20 after the 983, the form that is given for the STEM extension. They just give it to the DSO and get filed to that I-20. Do they need to file I-539 not only along with the statement, but also paychecks or the job confirmation letter that they have been continuously employed? Maybe, yeah, that may be required. I-539, as we discussed before, it's like a Russian roulette, guys. I mean, put a gun, put a bullet, and see if it's going to be. So you have to be very careful when you're filing an I-539 form. We yet don't know if the premium processing is allowed. We know the premium processing is allowed for the 765 form for the OPT. We know that premium processing is also there for the STEM extension. We yet don't know whether the premium processing will be there or not. We know for sure that the STEM extension people, the 180-day rule is still there. That means that if your OPT expires and your STEM extension is still pending, you can work for a period of 180 days. That rule is still there. They didn't took that rule off. Anything else, Cindy?
Yeah, I think the one thing I can't remember if we discussed it or not, the grace period. Did we discuss that? It's going to be a 30-day grace period instead of 60 days. So right now, if your program ends, your OPT ends, you get STEM OPT ends, you get 60 days to, do something. All right. Now it's going to be 30 days to do something. So just keep that in mind. That is going to be a major change. And I think along with that, I think my big recommendation for people is when you are researching guidance on this, if you watch this next year, or you're looking into this next year, look for current guidance. There's going to be a ton of information that is old. Our website probably has outdated information now, full of it, because we've written articles about how things were and not how they are. And it's easy to get trapped in that if you look at Reddit, you look at WhatsApp or whatever with old guidance. Make sure you are looking for things that are modern guidance with this.
Yeah, and I would just add, remember there is a 90-day limit of unemployment time. So when you are filing your STEM OPT, I would 100% expect USCIS to question whether you exceeded the 90-day unemployment limit time. So be prepared to provide employment verification letter, pay statements, W-2, possibly even the bank statements to show you actually received the money, that the pay statements were there. And then be careful of unpaid OPT. During the initial 12 months, unpaid internships are allowed, but they have to meet certain requirements under the Wage and Hour Fair Labor Standards Act. So not every single unpaid internship is properly unpaid. So you need to make sure that your company and you are in compliance with the unpaid intern rules of the Department of Labor. Otherwise, if you did 6 months of an unpaid internship thinking that you've not exceeded your unemployment time because you were working that time, and USCIS says, yeah, but it wasn't properly unpaid, you should have been paid, they're going to treat that entire 6 months as unemployment time, and they will deny your I-539 for that. So just be real careful about unpaid internships going forward with this new I-539 requirement.
We recommend that you subscribe to our blog, keep subscribing to our channel so that we give you fresh updates on what's going on in immigration, not just on student visa, but also can be L1, O1, P1, and also on non-immigrant visas and also green card applications. So please subscribe to our channel.